Be ready for dictation. 5 seconds. Start. In computing the period of limitation for any application, the time during which the applicant has been prosecuting with due diligence another civil proceeding, whether in a court or first instance or of appeal in revision against the same party for the same relief, that be excluded where such proceeding is prosecuted in good faith in a court which from defect or jurisdiction or other cause of a like nature is unable to entertain it, notwithstanding anything contained in Rule 2 of Order 23 of the Code of Civil Procedure 1906 within bracket 5 of 1908. The provisions of subsection 1 shall apply in relation to a fresh suit instituted or permission granted on the ground that the first suit must be failed by reason of a defect in a jurisdiction of the court or other cause of a like nature. The question is whether Section 14 of the Limitation Act has been excluded by this special enactment, that Arbitration and Conciliation Act 1996. Section 43 of the Arbitration and Conciliation Act 1996 clearly says that the Limitation Act 1963 shall apply to arbitration as applies to the proceedings in court. Therefore, general proposition is by virtue of Section 43 of the Act of 1996, the Limitation Act 1993 applies to the Act of 1996, but by virtue of subsection 2 of Section 29 of the Limitation Act, if any other period has been prescribed under the special enactment for moving the application or otherwise, then that period of limitation will govern the proceedings under that act and not the provisions of Limitation Act. In the present case, under the Act of 1996, for setting aside the award of any of the ground mentioned in subsection 2 of Section 34, the period of limitation has been prescribed and that will govern. Likewise, the period of condonation of delay, that is 30 days in proviso. But there is no provision made in the Arbitration and Conciliation Act 1996 that if any party has been bona fidely prosecuted its remedy before the other forum which had no jurisdiction, then in that case whether the period spent in prosecuting the remedy bona fidely in that court can be excluded or not. As per the provisions of Section 3 of Section 34, which prescribed the period of limitation within bracket 3 months for moving the application for setting aside the award before the court, then that period of limitation will be applicable or not the period of limitation prescribed in schedule under Section 3 of the Limitation Act 1963. Thus, the provision of moving the application prescribed in Limitation Act shall stand excluded by virtue of subsection 2 of Section 29, as under this special enactment the period of limitation has been already prescribed. Likewise, the period of condonation of delay, that is 30 days by virtue of proviso. I therefore, by virtue of Section 2 of Section 29 of Limitation Act, what is excluded is the applicability of Section 5 of Limitation Act, and under Section 3 read with schedule which prescribe the period of moving application. Whenever two enactments are overlapping each other on same area, then courts should be cautious in interpreting those provisions. It should not exceed the limit provided the statute. The extent of exclusion is however rarely a question of construction of each particular statute, and general principles applicable are subordinate to the actual words used by legislature. There is no provision in whole of the Act which prohibit discretion of the court under Section 14 of the Limitation Act if the party has been bona fidely prosecuting his remedy before the court which has no jurisdiction, whether the period spent in that proceedings shall be excluded or not. Over.